Okay. Mr. Stanley? You are muted. You need to unmute.
Microphone. Click on the microphone icon. There you go.
There you go.
Thank you. Good morning, Your Honors. Stephen J. Stanley for Calvin Cruz. From the record, it's obvious that the trial court judge has a profound misunderstanding of the evidence, which in and of itself mandates reversal. It's also clear from the evidence presented, this misunderstanding arose out of opposing counsel's misstatement of appellant's position to the court. And by the way, Your Honor, I'd like to reserve 5 minutes for rebuttal.
Sure. And while we're doing that, let me mention, have the Appellee's Council discussed how you want to share your time? Okay, well, I'll let you. I'm sorry?
We have. Do you want me to tell you what we've come up with?
You can tell me when it's your turn. So,
Yes,
all
sir.
right. Thank you, Mr. Stanley. I didn't count that against your time. Did you say you wanted 5 minutes?
Yes, Your Honor.
Okay.
Mr. Cruz never attempted to hide his previous injury to his shoulder and the recommendation for surgery by Dr. Longenecker. He could not remember Dr. Longenecker's name as the doctor that sent him to physical therapy. Nevertheless, Dr. Longenecker was listed as the referring physician, and the recommendation for surgery if physical therapy failed was disclosed in reports from John Gott's physical therapy provided to the defendants early in discovery. This is substantiated in the March 27 deposition.
Can I ask you a question? Because your argument seems to me it goes to intent, and intent is almost always a state of mind. So if your client did not intend to conceal something, the best way to figure that out would be for the court to have some sort of a hearing. Is that true or false? And did they have a hearing in this case, and the argument you're making today was made below?
Yes, Your Honor.
And the court reached a different conclusion?
Yes, Your Honor.
And is that based on an abuse of discretion? Because if it's abuse of discretion, how do we get the option to reweigh the evidence and come up with a different conclusion?
Because it's not only abuse of discretion in these kind of cases, a motion to dismiss for fraud requires clear and convincing evidence.
Right, and that's a mystical question. Where does evidence become clear and convincing and just evidence? I don't know the answer to that, but the case law will give us guidance.
Sure. Did that answer your question, Your Honor?
Yeah, you did. I didn't expect you to fall on your sword and say we lose.
Okay. Well, the fact that this evidence was provided is substantiated by the March 27 deposition of Mr. Cruz by opposing counsel. As mentioned, one of the notes was made, one of those therapy notes with Dr. Longenecker's name as a referring physician was made an exhibit to the deposition. When asked if he recognized Dr. Longenecker's name.
Mr. Stanley, you wrote a letter on September 13th, 2018, indicating that your client was a patient of Dr. Longenecker. And so you knew then that the medical records regarding the treatment with Longenecker at Jacksonville Orthopedic existed. And you didn't disclose that then, did you?
Well, first of all, I was inquiring about, based on seeing that Longenecker was listed as—
No, you weren't inquiring. You stated that your client was a patient of Dr. Longenecker.
Right, I was inquiring as to the records.
You were requesting records you knew existed.
Well, I didn't know what they were. I hadn't seen them. I wasn't aware of what there was. I know that Dr. Longenecker was the doctor that referred him to physical therapy because that's what it said in the physical therapy records. Also at that time, it was my understanding or my belief that opposing counsel already had the records.
Based on what?
Based on the letter that was sent to their CME, Dr. Marabella, with the request to do the CME and all the documents listed in the request. And, you know, it was my misunderstanding or my mistake. that they had them back in September when I requested them.
So your client then gives interrogatory answers that say he wasn't seriously injured in this fall, doesn't disclose this treatment or this physician. He testifies in his deposition that he sprained his arm. And this all happens before you write the letter asking for the records that obviously existed that hadn't been disclosed.
Yes, Your Honor. Mr. Cruz believed he had a sprain or a strain, which came out later in the records that that's what originally was diagnosed, and he went to physical therapy. It was almost like you have a choice.
Well, a sprain wasn't what was diagnosed. He was diagnosed with a serious injury that Dr. Longnecker thought required surgery and was willing to send him to PT as a stopgap or an attempt to avoid that. Isn't that right?
Well, that's partially right, but it's also in those records that the Orthopedic Institute, Jacksonville Orthopedic Institute, in their records also states that it was a sprain. Now, the MRIs indicate that it was a tear, but in any event, he went to physical therapy as ordered by Dr. Longenecker to see if he could recover without surgery, and that's what happened. He was able to improve to 95%. He was released from physical therapy on his own request, and he went back to work, where the evidence that he went back to work, and there were multiple bills of lading that are part of the record that from January of that year until he was injured in July at the Port Authority. So he did recover and went back to work without surgery. Does that answer your question, Your Honor?
Well, I not really, but I understand what you're saying.
Okay, well, shall I continue?
Please.
Okay. All right, so on appeal, the appellees failed to respond to many crucial parts of the initial brief. Appellees offered no response whatsoever to the everyone wanted to cut on him evidence, which was stated by Mr. Cruz to defendant CME, Dr. Mirabello. And despite it being featured prominently in the initial brief, appellees failed to even mention it in their answer brief. With regards to the claim that Mr. Cruz concealed Dr. Longenecker, appellee's omission of the final two crucial questions and answers in his March 2017 deposition on the subject in the answer brief is worth noting. I don't recall the doctor. I don't know, but I'm not sure. Thus, not only did appellees fail to respond to the arguments, but they also present a misleading view of his deposition testimony. On top of that, opposing counsel also entirely fails to address that Mr. Cruz stated that his wife and daughter would likely know, something that was ultimately supported by the medical records. There's no clear and convincing evidence of any scheme to defraud. Police also failed to meaningfully respond to the argument that Mr. Cruz should not have been penalized for the failures.
Let's talk about the hearing. We've read the briefs. You stipulated to an evidentiary hearing.
Stipulate the documents, documentary evidentiary hearing, which we submitted a multitude of documents. Yes, Your Honor.
I don't. If the record reflects that the evidentiary hearing was limited to a paper hearing, I'd like to have a cite to that part of the record. But you were given an opportunity to present. My understanding of the stipulation was that you were given an opportunity and spent 3 hours with Judge Battles. And during that time, you had the opportunity to submit documentary evidence as well as live testimony, although you did not present live testimony. Am I right about that?
Yes, Your Honor.
Okay. And when you were at the hearing, Judge Battles engaged in a fair amount of colloquy with you about your ability to show when you had delivered this information or when this information had been delivered to counsel. And your position was you didn't have the information with you at the hearing. You didn't have your computer, and you weren't able to satisfy Judge Battle's inquiry as to when this information had been disclosed to defense counsel. Do you dispute that?
I believe there was a misunderstanding of the evidence by Judge Battles. Dr. Mirabella had all those records that were listed by counsel in the letter they sent to him, and he went through all those records in his report that was made a record in the hearing.
Well, I don't think Judge Battles misunderstood that. I think he characterized it as being essentially you're giving them an opportunity to go find a needle in a haystack. Is that what you think was Judge Battle's misunderstanding of the evidence?
I definitely think it was Judge Battle's misunderstanding. Dr. Mirabella succinctly went through all the records he had. He didn't have Dr. Longenecker's Jacksonville Orthopedic Institute records, but he had the MRIs, all the prior.
But the MRI, that was Judge Battle's, one of his primary concerns during the hearing was that the MRIs were not the records concerning your client's treatment with Dr. Longenecker.
It's right.
Wasn't that?
But it was right in Dr. Mirabella's report.
I mean, you're telling us exactly what you told Judge Battles at the hearing.
Opposing counsel,
which was the MRIs are on there, and Judge Battles said, no, that's not my question. I want to know where the records from Dr. Longenecker are, and you said they're not there. I don't have them. I don't have a record stamp on it, but I'm looking at page 82 of the hearing transcript.
At the time that Dr. Longenecker, Dr. Mirabella was doing the CME, I didn't have any records from Dr. Longenecker. But what Dr. Mirabella had were the same MRIs that Dr. Longenecker reviewed. They were from
the MRIs that Dr. Longenecker reviewed are not Dr. Longenecker's treatment record. They're not the same thing.
Okay.
And this was essentially the argument you made to Judge Battles. Now you're making it to us and asking us to reach a different conclusion as to the significance of that evidence. That's not something we're generally empowered to do.
Well, I believe what I'm asking is for the court to realize that Dr. Mirabella had the records that he needed to make the decision that he made, and that that Mr. Cruz told Dr. Mirabella that everybody wanted to cut on him. The surgery was not, recommendation was not hidden. The only thing that Mr. Cruz could remember was the name of Dr. Longenecker. And yes, Dr. Mirabella didn't have Dr. Longenecker's records, but he had the records he needed for him to make a decision that the act that Mr. Cruz's condition was related to the first incident.
So, but your client did remember the names of, I think, 9 other physicians with whom he treated. And so Dr. Longenecker just couldn't, that was too much for him to remember?
I only saw Dr. Longenecker twice.
And he underwent several sessions of physical therapy under Dr. Longenecker's orders. Is that correct?
Yeah, but he went to John Gott's physical therapy. He didn't go to Dr. Longenecker.
But John Gotts didn't order the physical therapy. Dr. Longenecker had to.
Correct.
Isn't that right?
Yes. Well, may I go on, Your Honor?
Yes, please.
Okay. So, and, at the deposition, neither defendant chose to attempt to refresh Mr. Cruz's recollection by pointing Dr. Longenecker's name out and asking him about it. It would appear that the change of the previous 2 defense counsel, who already had Dr. Longenecker's name and surgical recommendation, to present defense counsel who must have failed to review discovery disclosures and deposition transcripts are to blame for not being aware of Dr. Longenecker and his recommendation for surgery, not Mr. Cruz. Mr. Cruz is not responsible for counsel's lack of
Mr. Cruz is responsible to disclose his history. Do you disagree with that basic premise?
No, I don't.
You're essentially arguing that, notwithstanding Mr. Cruz's inability to recall very much at all about Dr. Longenecker, that it was defense counsel's responsibility to unearth, despite the fact that they were told twice in discovery, nothing about Dr. Longenecker. And so your argument sounds to me like that was defense counsel's, it wasn't our responsibility to disclose. If we gave them a universe of material and it was in there somewhere, they should have found it.
I disagree, Your Honor. They had it. They had the record with Dr. Longenecker's name. They made it an exhibit to the deposition.
Well, you had that too. And you had your client who knew that he treated with this doctor. What about you refreshing his recollection when you're preparing interrogatory answers?
Mr. Stanley, I can see you probably aren't going to concede that issue. Do you mind if I ask you a little bit of a different question?
Sure.
I think one of your backup argument is, hey, let's assume maybe there was some lack of candor. And if there was, we're not conceding there was, but if there was, the remedy the court fashioned for dismissal was over the top. There was a lesser sanction available. So my question is, what was that lesser sanction in your mind? What should it have been?
Well, you know, well, I disagree that a lesser sanction is appropriate. If there was a lesser sanction, there could have been some type of a fine that Mr. Cruz would have had to pay for attorney fees.
How would that have satisfied the other side?
Well, it probably wouldn't have satisfied the other side. Nothing was going to satisfy the other side other than an outright dismissal. I mean,
and you did argue in your brief that this is an argument that you made as a backup argument. Did you make that argument in the trial court, or were you hell-bent for leather on this is not suitable for dismissal and they knew what they knew and let's move on?
probably the latter. I mean, I probably brought up there could have been a lesser sanction.
Well, that's my question. Did you bring that up in the trial? Where is that in the record before the trial court?
I really don't know right now, and I didn't offer a particular lesser sanction.
And Mr. Stanley, you're down to your rebuttal time, so you use your 5 minutes as you wish.
Okay, I'll pass.
Okay, great. Okay, defense lawyers, what have you worked out?
We have worked out that we'll split our time evenly, 10 minutes apiece. I hope not to use my 10 minutes, and I spoke with Ms. Waller prior to today about how do we split this up. I think she is more prepared. Of course, she's prepared to discuss it all, but insofar as any questions that might have to do with cases cited by the appellant and how they might be distinguished.
Okay.
So hopefully that makes sense.
All right. So who wants to go first?
I'll go first. My name is John Guyton, and may it please the court, my law firm represents Kincart Construction, the appellee in this case. We were representing Kincart at the trial level, and I was intimately involved in the case at the trial level. And I'll rely on the briefs and the detailed extent of the trial court's 10-page single-space order following an evidentiary hearing wherein he granted the relief that we sought. Those express findings of fact, his conclusion that there was clear and convincing evidence about intentional concealment, and clear.
Mr. Guyton,
yes, ma'am.
I don't know if this is how this is divided, and if you want to pass this to your co-counsel, I'm fine with waiting for my answer. But the issue of eventually this information was disclosed. I'm sure from your perspective, it was not timely disclosed. And then by the time it was, I think it was in response to the motion to dismiss. And given that that disclosure was made, and other than the fact that you'd gone through all this discovery, what's your position on whether that should, having gotten the disclosure before you're going to trial, that dismissal was too harsh?
Well, I'll rely on a case that we cited, Baker v. Myers Tractor Services, about an attempt to cure an intentional concealment, and that simply doesn't cure the transgression. And so I will answer your question by saying the attempt to cure, and I'll also rely on the day after we filed this motion to dismiss, lo and behold, we get these records. So I think that belies the intention involved, who knew and knew when. So I don't think the belated disclosures cures the transgression.
Well, do you agree it was preserved, that backup argument? It was argued below and preserved for appeal?
I do not agree that the issue of a lesser sanction was brought up at the time of the hearing, at the time of the dismissal.
Okay.
Finally, I don't want to belabor the point, but the second DCA in both the Morgan decision and in the Ramey decision express the standard of review, and it is abuse of discretion. And I would submit respectfully to the court that the non-disclosure, particularly of a surgical recommendation in the very calendar year and the year before this incident occurred in July of 2014, is much more serious and much more egregious than the non-disclosures in both Ramey and in Morgan.
And let me ask you, since I gather that you took the lead on case law for this, right? So, and again, if it's your co-counsel who's better situated to answer, I'm happy to take it from her. Your argument is Ramey is basically on all fours and this case is more egregious.
Yes.
Your opponent counters or takes the position that Duarte is the better authority here. Tell us why it isn't.
I think the distinction is, and my co-counsel can correct me if I'm wrong, in Duarte, there was no evidentiary hearing. Hopefully I'm right on that. And in this, we had the 3-hour evidentiary hearing wherein the trial court was going to assess the...
I'll help you out. I read Duarte yesterday. There was no evidentiary hearing.
Okay.
So that's your position. It's the difference between the Ramey and the case on which it is based. Both involved evidentiary hearings like the ones we had here, whereas Duarte was essentially a summary proceeding on paper.
Yes, and I think the cases talk about greater deference is given to the trial court, its findings of fact, following an evidentiary hearing as opposed to a paper analysis.
Fair enough. Thank you.
So to sum up what I have to say, did the trial court abuse its discretion by imposing an unreasonable sanction? I would submit to you that in both Ramey and Morgan, our answer is found, and the answer is no, there was no abuse of discretion, and that those two cases are on all fours insofar as the trial court's conclusions, its decision, and we're asking that the trial court's decision to dismiss this case be affirmed. Thank you.
Thank you, Mr. Guyton. Ms. Waller, there's about 15 minutes left, so you don't have to restrict yourself to 10 if you don't want.
Good. I appreciate it. Thank you. May it please the court, Madison Waller on behalf of Tampa Port Authority. Unless your honors have any questions that you'd like me to begin with, I'm just going to do my best to address some of the points raised by counsel for appellant. One of which was the allegation that the defendant's failure to refresh the appellant's recollection is somehow an excuse of Mr. Cruz's failure to name Dr. Longenecker. And to that point, I think that this court would find the Di Stefano case, which is cited by Judge Battles in his order, instructive. That's a first DCA case from last year. Very factually analogous. There was a failure of the appellant to disclose relevant accidents and injuries, both in deposition testimony and in interrogatory responses. And there, the opposing counsel actually did refresh the appellant's recollection by showing them an accident report, after which time an undisclosed accident was admitted to. And there, the appellate court very clearly said that although the appellant claims poor memory, and even despite this having refreshed their recollection, nevertheless, it's appropriate to maintain dismissals for fraud.
I'm apologize for interrupting you. I think we can get to the point though. Mr. Cruz's argument is that, you know, he had some mental infirmities, memory issues, and that would be an excuse, it was an explanation for the deficiencies in the disclosures. My understanding is that his wife is a nurse and that she accompanied him to at least some of the appointments or some encounter with Longenecker, that she was aware of that. I don't want to hear about what's not in our record, but is there anything in the record that it has to do with whether or why either of the Cruzes did not attend the hearing with Judge Battles? Because it seems like that would have been a good opportunity to explain the situation with regard to what he remembered and why or not.
I agree, Your Honor. No, if anything, what's in the record is Judge Battles' insistence that live testimony would have been important. And the court's order says as much in a footnote that this hearing was rescheduled from November to January for a 2-hour evidentiary hearing, so that, you know, in part, so that live testimony could be had from Mr. Cruz, especially with regard to, as Your Honor mentioned, these alleged cognitive deficiencies. So we don't have preserved in the record, for example, evidence speaking to memory failures or.
And that was one of the things that Judge Battles noted in the order, isn't it? That while counsel argued about cognitive deficiencies, there was no evidence admitted on that. Now, and I just need to understand this. Those records were part of the evidentiary book, if I'm not mistaken. And at the beginning of the hearing, I believe that defense counsel stipulated that those records were admitted as to authenticity and they were non-opposed as to authenticity and admissibility.
Correct, for the purpose of the evidentiary hearing, yes.
But your argument is effectively the documents without more were insufficient evidence of the cognitive issues?
Correct, Your Honor. Defendant's position is that based on the record evidence, there is insufficient evidence that Cruz's failure to disclose Dr. Longenecker, the surgery recommendation, and the Jacksonville orthopedic records was the fault of a memory issue. And Judge Battles even looked at what was in the record to see that there were some curious timing issues, namely that following the February 2012 Houston fall and before the instigation of the litigation, there's a litany of physical therapy recommendations which evidence discussions between appellant and the physical therapists regarding, for example, the surgery recommendation. So it's curious that prior to the litigation, the appellant was very much aware of surgery recommendations So there are in the record indications based on the chronology of when the appellant remembered surgery recommendations and discussed them. Then as soon as litigation began, all of a sudden, there were some failures of memory. And as Your Honor pointed out, the failures of memory were solely with respect to one doctor out of 10, and it happened to be the doctor who arguably had the most detrimental or potentially detrimental evidence in terms of the similarities of the injury. Just to continue regarding some of the other points raised by counsel for appellant, regarding the argument that Dr. Mirabello, the defendant's doctor who performed the CME, had all of the records, it's very clear that all of the records were not had at that time. Indeed, neither Dr. Mirabello nor, more importantly, the defendants themselves had all of the Jacksonville orthopedic records. Indeed, those were had through a non-party subpoena much later. So, I would posit to the court that perhaps it's irrelevant that a CME doctor had some records, because those are not the records at issue here. The records at issue here were Jacksonville Orthopedic Institution records that were not timely disclosed. If Your Honors have specific questions regarding any of the cases or issues, I'd like to address any of those in turn. Otherwise, I could just sort of continue based on the brief to present some discrepancies.
Okay, thank you, Ms. Waller. Mr. Stanley.
Thank you, Your Honor. Well, first, I'd like to point out what Mr. Cruz forgot is very narrow. It was Dr. Longenecker's name. What I'd also like to point out is there were substantial records in this case at the hearing of evidence of cognitive and or memory impairment. It's shocking that the records are said not to have been there. You had Dr. Nicole Cannon's opinion in the records that Mr. Cruz suffered memory issues, but notably even defendant's own compulsory medical examination neurologist, Dr. William Greenberg, suggested that these cognitive deficits could be valid. Dr. Greenberg, their doctor, even surmised that it's plausible that these complaints could be interrelated to his chronic pain.
So, excuse me, Judge Battles addressed this evidence, what you're talking about, and I'm looking at page 8 of the order, and he evaluated it and concluded that the records that you're talking about were not evidence that his memory loss contributed to the failure to disclose, and specifically dealing with Dr. Longenecker. And he also pointed out that the documents showed that among the documents that were in evidence, that your client revealed the information very temporally close to when he didn't disclose it. So that's a long-winded way of saying, I think that what I'm hearing is that you would like us to revisit Judge Battles' evaluation of that evidence and his conclusions about its sufficiency or lack thereof. Am I right?
Well, first of all, I don't understand how that Judge Battles could have interpreted that the evidence wasn't there when it was there. All this evidence that's before you, it's in the record.
Well, I don't think he interpreted that it wasn't there. I think he interpreted that it didn't do what you wanted it to do.
Yeah, I don't really understand the point I hear that you're making is that Judge Battles didn't agree that the records showed that he had cognitive and memory issues. That must be, is that what you're saying?
Well, you've read the order, right? I mean, he devotes a good long paragraph to explaining his view of that evidence and what it established and what it didn't, and why it didn't, given the other evidence that was in the record showing when your client was aware of and was able to recall his encounters with Dr. Longenecker and what the outcome of those were.
Well, I think the trial court failed to take into account Mr. Cruz's significant and well-documented neurological limitations, including his difficulties in recalling information and his significant executive function cognitive deficits when it evaluated his testimony. As such, it was error for the court to not at least consider these deficits. And that's Simons versus Henderson, 745, 7-2, 1031, a second DCA case. Reversing a case that was dismissed for fraud upon the court because the trial court failed to properly consider the reduced cognitive capability of the litigant. And also a case cited by appellees that says, first of all, Dr. Longenecker's name was provided in John Gott's physical therapy notes that we've talked about, and it was disclosed and discussed at the March 1 deposition. But reversal is justified as the trial court clearly erred in its interpretation of the facts and the use of its judgment in light of the evidence disclosed and presented regarding the prior injury in Houston, the diagnosis and treatment thereof, as well as evidence of Mr. Cruz' memory limitations. And that's Mercer versus Rain, 443, 7-2, 944, Florida Supreme Court's 1983, to justify reversal of sanction imposed by a trial court for discovery violations. It must be shown on appeal the trial court clearly erred in its interpretation of facts and use of its judgment. That's a case cited by appellees in their brief. You know, I guess it's just clear to me that the only thing that wasn't, the surgical recommendation was disclosed. There's no question about that. It was in the physical therapy records. It was in Dr. Marabella's CME examination. Mr. Cruz told Dr. Marabella that everybody wanted to cut on him. I mean, it was just not hidden. The only thing that he couldn't remember was Dr. Longenecker's name. And that is related to his cognitive issues. Now, am I asking you to reevaluate all the evidence? No, I'm asking the court to say, here's the evidence. Was it properly considered? It doesn't seem to me that it was considered. Seems to me that there was a misunderstanding by Judge Battles of what Mr. Cruz's point was. And Mr. Cruz just didn't remember Dr. Longenecker's name. He didn't hide the surgery recommendation. And so this case was dismissed.
Well, he didn't disclose the surgery recommendation, did he?
Yes, he did disclose the surgery recommendation. When we provided the discovery on John Gott's therapy, it was in there. When Mr. Cruz was interviewed for CME by Dr. Marabella, he told him then everybody wanted to cut on him. I mean,
hey, Mr. Stanley, you're at the end of your time.
Well, I would close and say that I expect reversal is warranted based on what was presented and what was relied upon. Thank you.
Okay. To leave, you press, there's a button in the lower right-hand corner of your Zoom screen. And if you click that, that takes you out, and then we'll call the next case.
Have a nice day, everyone.
Thank you both.